Hey everyone, so I wanted to hop on here and just talk to you about the case of the state of Georgia against Leilani Simon. For those of you who may not be familiar with the case, Leilani was accused of murdering her precious son, Quentin Simon, and disposing of him into a dumpster where he was later recovered from a landfill. And so she is facing charges for his murder. Case number is SPCR 22-03364-J6. Tammy Stokes is the judge presiding over the case. And so today they went over a lot of topics regarding media coverage, lots of perspective from both the state and the defense team, concerns for Quentin's surviving siblings and them not seeing live streaming across the internet and social media as they get older. Also wanting to make sure that there's a fair trial for Leilani, and so the defense brought those topics up as well. It sounds like they are not going to authorize the live streaming of the trial, but they will allow for media to come in and report using pen and paper, and they will look at video reporting on a case-per-case basis. Other topics that came up during the hearing was the Department of Children and Family Services records that Leilani's defense team had requested be turned over to them. So apparently those have been approved to be turned over to her team. And then it came up about the journal entries and any kind of writings, letters, notebooks, anything that Leilani may have had in her home that she lived in with her mother, Billie Jo Howell. The judge called Billie Jo up to the stand, and Billie Jo turned over several books, notebooks, journals, any documentation that was being requested from the judge. Billie Jo, her demeanor was saddened. Her shoulders hung low. She also appeared to be very monotone. She spoke very politely and kindly to the judge, very respectful. And so anyway, I went ahead and attached the video of today's hearing. So let's jump into it, give it a listen, and thanks for joining.
All rise. Chaffin County Superior Court is now in session. Only Judge Tammy Stokes presiding. Be seated and come to order.
All right, good afternoon, everyone.
Good afternoon, Your Honor.
So let's begin with the call of the case. Let's see. We are here today for SPCR 22-03364, State of Georgia versus Leilani Simon, and Bob Attridge and Joe McNary are here for Ms. Simon, and we have Shalana Jones and Tim Dean here for the state. We're here, the case is scheduled for, and was originally scheduled for a status conference, which is usual for the beginning of a criminal case. The media, of course, expressed some interest in that case. And so the court received several requests for permission to record as well. Fortunately, Judge Carr appeared at the first hearing that was set on June 25th. It indicated this court would issue a detailed ruling as to the Rule 22 hearing and the recording of the proceedings at a later time. So first I want to address the issue of the Rule 22, the request for permission to record. I have spoken with both attorneys for the state and attorneys for the defense. And I would like to ask you briefly if you would state your positions on the record with regards to recording.
Your Honor, Tim Dean for the state. The state is objecting to any recording, photographing, live streaming, broadcasting of any of the proceedings in this case, pretrial or trial. Probably, admittedly, applies with more force to substantive motions hearings and the trial than it does to this proceeding. But it centers around statutory factor H, any special circumstances of the parties, witnesses, alleged victims, or other participants, such as the need to protect children, or factors involving the safety of participants in the judicial proceeding. And I think that, so that's the center of gravity for our argument against allowing recording, broadcasting, live streaming. And it probably differs from what the defense is focused on in their opposition to such requests. But our concern here is that the victim in this case, Quentin Simon, has two surviving siblings. And they have privacy interests. They're not of an age to consent to recording or broadcasting of a proceeding that sort of, while not directly about them, touches on their life and their circumstances to some degree, inextricably and unavoidably. But our position is that obviously under the First Amendment to the United States Constitution, media personnel have a right to be present for the trial and to report on it with pen and paper and write stories about it. And that right can only be abridged in very narrow circumstances along the lines of courtroom closures. But there is no constitutional right to broadcast, televise, live stream, or photograph the proceedings. The two things are just different. And our position is that with respect to those two surviving children, there's just a qualitative difference in their being existing on the internet as they reach the age of majority and go into adulthood. Some scattered print news stories about this case and about their family and about this tragedy, and there being a recording of the entire proceedings about their mom and their brother existing online in perpetuity, to be replayed and probably cut up into highlight reels and blooper reels and things like that, because these are the things that happen with trial footage. And so that is our position. These children are the subject of a parallel proceeding in juvenile court. I think it's illustrative, if not controlling, that records of that proceeding are not accessible to the public, and that while juvenile court proceedings of the nature that they're involved in are normally open to the public, they're not open to the public in this particular case because the juvenile court judge who's presiding over them has put into place an order closing the courtroom based on her analysis of all the factors and interests in play here. I'm aware that we may have to argue this in more detail later for the purpose of future hearings that are set in this case, and may have to make an evidentiary record supporting our position. But insofar as the court is just asking us to briefly state our position today, that is where the state is at on this matter.
Thank you.
Good afternoon, Judge.
Good afternoon.
Your Honor, I respect the state's position in a lot of ways. I agree with them. My concern is protecting my client's right to a fair trial and having a potential jury coming in here that's impartial, and to ensure that people are not coming into a courtroom with outside information that may prevent them from being impartial. I look at this from the perspective of the news media as well as social media. As far as the news media, which is the Rule 22 we're dealing with today, I have no problems with any type of recording or whatever they want to broadcast for today's hearing. I also believe that the court should not grant a blanket Rule 22. I read the rule to require that every hearing there must be a procedural request to record that. As the state pointed out, there could be some hearings such as the status check where there may be non-evidentiary matters which I may not have an objection to, but there may be some evidentiary hearings which I would have an objection to. So I don't have any problems today. I also agree with the state's analysis that an open courtroom does not necessarily mean this, and the right to the press does not necessarily mean they have a right to videotape proceedings. They have a right to be present, to witness, and to report. But this idea of videotaping, I don't think is a right that they have under the Constitution. And as I mentioned to the court in chambers, if such a right existed under the U.S. Constitution, then they would be recording in federal court. We know that just does not take place. So the court, I think, has to be looking at this from a balancing test, protecting the defendant's right to a fair trial and protecting the press's right to freedom of speech and freedom of press, and the court will. I understand that. So that's, I have no objections for today reporting it, but I think for further hearings, I think we have to go on a case-by-case basis. As far as the social media aspect, I don't want to get into the live streaming or not, but you asked on Rule 22. But as far as the live streaming, I would oppose to any live streaming based on the fact that you do have some control over the news media, but you have no control over social media and what goes on out there. And live streaming, I think, just creates a frenzy in social media. And I think, in my opinion, there's a lot of misinformation out there in social media. It thrives on misinformation, conspiracy theories, all these things. And I will be opposed to any type of live streaming to prevent any type of social media misinformation. That's my position on the Rule 22.
Thank you, Mr. Andrews. I will say that certainly when it comes to the Rule 22, and whether or not the media will be allowed to record at various hearings, it certainly is a balancing test. And there is a balance of many of the things that the state has mentioned, as well as defense, the lives of the folks that are involved, the ability to get a fair trial, social media, even though that's not a part of it, it certainly is an ancillary part. I will state at this point, after consideration, I am not going to live stream. That will not happen in this case. I will not issue a blanket permission to record the proceedings, and of course the media has the right to be present. The courtrooms are present. The media has the right to come in, hear, report, but a Rule 22 request for permission to record has to be presented each time. So there's no blanket no, there's no blanket yes. It will be handled on a case-by-case basis. I am going to rule as we go and as those requests come in, and I'll take all of that under advisement. As to the issue regarding the defects records, the court has those records now and will conduct an in-camera inspection, and I will provide access to those records as they are reasonably calculated to lead to the discovery of admissible evidence. And the last thing, third matter at this point, is regarding the defense's motion to quash the state's subpoena for the production of evidence This was a subpoena to Billy Joe Howell, also known as Billy Joe Betterton, for any and all diaries, writings, letters that belong to Leilani or jointly with Leilani Simon. I understand that those records have been produced today, and the court will take them into custody and safekeeping and hold those. We will put the hearing down for a later date regarding the defense's motion to quash. Other than that, we're here today for a status conference. We've talked some about how discovery will proceed. I understand that there is a lot of evidence and discovery that is coming in and will be coming in on a rolling basis. Some of that will not be able to be handled with a set scheduling order the way we may normally handle that. That will have to be a little bit more fluid, and of course we will take each of those things under consideration as we continue. Anything else from the state?
Nothing from the state, Your Honor.
Next.
Can we have Ms. Howell come forward on the record and produce those records to the court? Ms.
Ms.
Howell?
Howell. I want you to look at those records. And for the record, ma'am, you are Betty Joe,
Billy Joe Howell.
Billy Joe Howell.
Yes, ma'am.
All right, and Ms. Howell has just handed in a number of booklets. I am counting 9. Eight total books / notebooks that have compilations of information within them. I will take this evidence and we will hold it in safekeeping. Thank you for bringing those documents. And is there anything on the record regarding Ms. Howell that should be placed on the record to perfect things at this point?
Judge, I am going to have her testify when you do set the matter for the motion to quash, so at this time, I don't see any need to have her testify.
Ms. Howell, you will not testify today. You will be notified of a later date for your testimony.
Yes,
Thank you for being here.
yes, ma'am.
If there is nothing else, we stand adjourned.
Right, thank you, Judge.
Thank you, Your Honor.
Thank you, Judge.
Yes.
I think we should.